Foundation, and the local Dhaka Chamber of Commerce and Industry and the Metropolitan Chamber of Commerce and Industry, Dhaka, are sponsors of BIAC. The International Finance Corporation, the private sector arm of the World Bank, with funds from the UK Aid and European Union, had supported BIAC in the initial stages under a cooperation agreement. BIAC provides a neutral, efficient, and reliable dispute resolution service in this emerging hub of South Asia's industrial and commercial activity. BIAC aims to embed the use of ADR as a commercial best practice to facilitate the creation of an ecosystem that fosters investment and is conducive to business. BIAC is committed to be a credible and a sustainable national institution that aims to offer international commercial best practices on ADR services to individual and institutions seeking to resolve commercial disputes. Since its inception in 2011, BIAC has been recognized by 62 national and international institutions, including the Permanent Court of Arbitration, The Hague, the Netherlands, and many other international ADR centers, local corporate companies, financial institutions, real estate companies, NGOs, universities, and the law firms in Bangladesh. Membership. BIAC offers membership to practitioners, stakeholders, students, and interested individuals at home and abroad to create a knowledge and resource sharing platform. A few words about outreach programs. BIAC have organized 155 workshops, seminars, and webinars so far. Although COVID-19 has frustrated holding of many of its events, BIAC hosted a number of webinars jointly with its local and regional partners. BIAC also organized a national consultation session based on the request of the Law Commission Bangladesh on proposed Arbitration Amendment Act 2018 by a Law Commission Bangladesh, and the recommendations from the session on the proposed Arbitration Amendment Act 2018 were sent to the Commission. We have proposed to the University Grant Commission and the Bangladesh Bar Council to include ADR within the academic curriculum in order to raise awareness and popularize this alternative procedure within the country. UK Foreign and Commonwealth Office recognizes the role of BIAC in their publication, Bangladesh Doing Business Guide. This guide is for British businesses who are interested in developing their overseas trade in Bangladesh. US Embassy also recognizes BIAC as a forum for resolution of US citizens' trade disputes and enlisted BIAC in their list. We humbly welcome the generous support and contribution of the Citibank Limited and also the academia and the students for participating in the contest and making it a successful one. Thank you all and best wishes for the participants. Thank you.
Thank you, sir. We will start the contest now. So before starting the contest, I would request both the claimant and the respondent to introduce their respective roles in the case, and the floor is now being handed over to the arbitrator of the session.
The coordinators, please take lead and introduce your team members, please.
Dear Honorable Arbitrator, a very good afternoon to you. I am Nafsun Hassan, and I am the coordinator of the claimant, Hydropump PLC. This is an arbitration for the settlement of the dispute between Hydropump PLC, the claimants, and Turbo Energy Limited, the respondents. In such, the opening statement will be presented by Mr. Mahir Chaudhary, who is the senior legal counsel, and he will be speaking for 10 minutes on the part of the claimant. The senior legal counsel will also conduct the examination in chief of our first witness, Ms. Masha Farade, for further 7 minutes. After the cross-examination by the respondents, the junior legal counsel, Mr. Mehrab Subhan, will conduct the examination in chief of our second witness, Mr. Gillian Lawson, for 7 minutes, whilst the senior legal counsel will then conduct the final examination in chief of our third witness, the representative of the Riverdale Tidal Power Plant, on the part of the claimant for 6 minutes. All cross-examinations of the respondents will be then conducted by the junior legal counsel, Mr. Mehrab Subhan, for 10 minutes. This will be followed by the final closing statement by the senior legal counsel, and he will be speaking for 10 minutes. With this, I will be closing my statement, and I would like to call upon our senior legal counsel to begin the arbitration process upon permission from the Honorable Arbitrator.
All right. Your time starts now. Please proceed.
May it please the Arbitration Tribunal, my name is Mahir Chaudhary. I am the senior legal counsel. And before I start off with my main arguments, would the Honorable Arbitrator want a brief statement or summary of the facts?
The tribunal opines that whatever has been given in the instruction be followed in letter and spirit, and parties are advised to not seek clarification beyond those. Thank you.
Much obliged. So, under the situation, in the circumstances, the claimant is Hydropump Energy Company. Sincerely apologize. Hydropump PLC is the claimant side, who are an installation company of turbines and hydropower pumps, and a Green City is a city which requires the use of renewable resources of energy. So Green City has opened up the agenda and a tender whereby the claimants have entered into a contract with the respondents being Turbo Energy Limited. Turbo Energy has produced a description of the specific turbines that specifically comply with the tender agreement between the claimant and Green City, whereby the claimant and respondent entered into a specific contract. And the main breach of contract or dispute arose due to the fact that the turbines that were delivered by the respondent, and they turned out to not represent the actual description and actual quality of the products that were required, whereby the claimants and the Green City required a replacement and the respondents refused to do so. The counsel for the claimant imposed and started the arbitration process as per Article 21, subsection 2 of the sales agreement, whereby the claimant has a right to an arbitration under BIAC arbitration rules 2019. Now, under the main arguments for the claimant counsel, it is divided into 4 parts. Under the opening statement, the claimant counsel will be firstly dealing with the first 2 parts of breach of terms by the respondent and fraud committed by the respondent. The counsel contends that there exists a contract between the claimant and the respondent under Section 10 of Contract Act 1872, and there have been 2 counts of breach of the terms of the contract, whereby these include, firstly, based on the product quality, and secondly on inspection and maintenance of time intervals between the checks and balances available. Under Part 1, the product description that was provided by respondents in relation to the terminals included that they were extremely corrosion resistant as per para 4, page 4 of the facts. However, it turned out that the characteristics of the special alloy had been altered by heat during the manufacturing process, and this is specifically stated in para 3, page 3 of the facts. So evidently, this shows that there has been an actual change in characteristics of the turbine, and it is not merely a possibility that makes the turbines at risk of corrosion and breakage, but there is a direct link between the quality of the turbines and the fact that there would be that it is sensitive to future corrosion and breakage. Moreover, breach of implied terms under statute have also taken place, and the case of Hutchison represents the validity of these implied terms under statute under the Bangladeshi jurisdiction. That is applicable under the current sales agreement. The Sales of Goods Act adhere to a description that was made. It must adhere to a specific description that the respondents failed to maintain, as per mentioned and proved already that the turbines that were delivered were susceptible to corrosion Furthermore, under Section 16, it states that where the claimant had already communicated to the respondent that the particular purpose of the entire agreement was that they must meet the tender agreement requirements as per mentioned under the sales agreement under Article 2.1. Their entire purpose of entering into the contract with the respondent was so that respondents could provide them with the turbines that were necessary under the tender agreement. However, Section 16 also requires that the claimant rely on the skill and judgment of the respondents. And here it is extremely apparent that claimants relied on the specific knowledge and skill as per showed by Judge Hazra's commentary in Bengal Corporation PVT, where he mentioned Lord Wright's judgment in RT Grant and Lord Buckmaster's judgment in RIA Limited, whereby reliance on respondents' knowledge and skill could be adduced simply from the conduct of the parties, and the conduct communication therefore proves that here in the circumstances these are the Section 16 applies. Furthermore, in relation to the second part of breach of terms, in relation to the inspection and maintenance time interval, the specific Article 2.1d of the sales agreement requires that the first inspection of the turbines after the first operation starts, it be after 3 years from the first date of operation. However, as per para 5, page 3 of the facts, the respondents sought to bring forward the date to September 2023 after only 1 single year of operation. This is in direct breach of an express term of contract of effect in breaching another aspect of Article 2.1.d that the sales any operation or maintenance be taken place within 2 months period between September and October. However, these inspections that would be carried out whereby the respondents do not agree to the replacement that is required, It states directly in para 8, page 3 of the facts that any repair would mean that the turbine and therewith the plant would be out of operation for at least 4 months. And this would be a frequent occurring, that the plant would be unavailable to produce the necessary amount of energy that is required from it. And this breaches all the main purpose and fundamental purpose of the contract. Furthermore, Article 2.1.e is also breached, whereby minimum interruption of the availability of the plant for the production of energy must be ensured by the respondents to the claimant side. This point is directly in fundamental breach, whereby the facts, as per mentioned before, the respondents require regular maintenance and inspection checks. Under issue 1, the claimant counsel has proved 3 different counts of breach of express terms under the sales agreement and 2 counts of breach of implied terms under the statute. Furthermore, the claimant contends under the second issue that the respondents are liable for fraud under section 17, subsection 2 of Contract Act 1872, whereby it states that it relates to the active concealment of a fact in order to benefit oneself or one's company. So there has been a specific scenario as per line 5, para 32, that on that of the Riverdale Tidal Power Plant. This is a power plant that had to close down in May 2021 after only 2 years of operation. And this power plant had used the turbines produced by the respondent. So due to, and the plant had to be closed down due to damages of the turbines. Now, this was known by the respondents 1 year before they delivered to the claimants the specific turbines under the sales agreement under the situation. They knew for a fact that the materials they were using in the sale they were using to produce the turbines that were under the contract and the circumstances were manufactured with faulty steel. They knew this because they are as per the facts a huge company that is supposed to run huge checks and balances, and where such a huge situation has occurred where a power plant had to close down for 13 whole months after only 2 years of operation. They are supposed to take into account the circumstances and check and balance the situation. Now they only informed us about this after they received the payments and after we saw we from the claimant side, the claimant side had seen a specific article published on the matter, after which they had informed the claimants of the situation, and whereby this leads to a specific breach under the sales agreement this leads to the fraud of the situation, because they already collected all the payments under the sales agreement before even acknowledging or letting the claimants know about the circumstances that there was a possibility of the use of defective steel to use their products. And in this, the case of official receiver Jhansi, Judge Mukherjee had a similar and reached a similar decision where the facts were similar in the case.
You have taken 2 minutes more than 10 minutes allotted for the opening statement. You are most welcome to carry on, but the same time will be adjusted in the overall time allotted to your team. Please proceed.
Much obliged, Honorable Arbitrator. With that, as I have finished off the issues 1 and 2, and also argument 2, based on the fact of fraud of the respondent, the counsel would now like to begin the first examination of chief of the first witness.
Before the examination chief starts, let me reiterate the directions and the instructions passed in writing to all of you, that whether you produce the required number of witnesses or more or less, up to you, but the time allotted will remain same. And it will be adjusted in the overall time allotted to the team. Thank you so much. You may proceed.
Also, obliged arbitration our arbitrator. I would like to call Ms. Maisha Faraday as the first witness.
Yeah, please proceed.
Please would you like to introduce yourself, Ms. Maisha Faraday?
Honorable Tribunal, my name is Maisha Faraday, and I am the Chief Executive Officer of Hydropump PLC.
Now, Ms. Faraday, what was the main reason for you entering into a contract with Turbo Energy Limited?
Well, we only entered into a contract with Turbo Energy Limited because their water turbines that they produce had the characteristics that would allow us to win the tender agreement with Green City.
Noted. And what were the main factors that led you to winning this tender agreement with Green City?
Upon the invitation of tender by Green City, I had submitted a bid on behalf of my company, Hydropump PLC. One of the vital reasons behind us securing the contract was the inclusion of R27 franchise turbines produced by Turbo Energy Limited. They had stated that the design is environmentally friendly, only requiring 2 turbines to produce 600 megawatt of energy over a period of time. That, due to its design, it allowed longer time intervals between inspection and maintenance checks. Furthermore, Turbo Energy Limited had given a description that the turbines were designed in such a way that they were extremely corrosion resistant, which met the Green City's requirement. That would allow at least 11 months of operation in a year for the Green City with the help of turbines. As the characteristics of R27 franchise turbine complied with the mentioned requirements of the requirements put down by Council of Green City, the Council of Green City had awarded us with the contract.
And Ms. Faraday, what is the dispute for which you sought arbitration here?
We wanted an assurance from Turbo Energy Limited on the material used to manufacture the turbine, where they were unable to do so and pulled forward the first inspection by 2 years from the decided time to ensure the quality of material used. Since they couldn't ensure and give us any confidence over the turbine, Green City had urged us to ensure a replacement of the blades in the turbines, to which the turbine and Turbo Energy Limited refused to do so and informed us that they will repair the turbine in case any issue is found, which will reduce the productivity of the plant. At the same time, any repair will further address the symptom and not the cause, the inferior state. Also, any breakage of the blades will have detrimental consequences not only for the turbine but for the plant too. Hence, why we request the arbitration panel to help us find relief. Because under the tender agreement, we have to pay a penalty to Green City of 40 lakhs per day as they have to use carbon energy.
With that, the first witness examination in chief will come to an end, and we would like to start with the cross-examination by the
Respondent may please proceed with the cross-examination.
Greetings, everyone. This is Shweta, Examiner-in-Chief. Hello.
Yep.
Am I audible?
Yep.
Hello.
Yes, you are audible.
Greetings, everyone. This is Shweta Thapa, cross-examiner. So, Ms. Faraday, so you were the first one to get informed about the first document of the Good Steel Company.
Could you repeat your question, please?
So you were the first one to get informed about the first document of the Good Steel Company.
The news was given down by the newspaper by the newspaper itself. So it was not just me who got to know about the information, but it was the world who got to know about the information, because the information was put down in the newspaper, which goes to everyone. So it's not me, the first person who got to know about it. It was everyone in this world who got to know about it, wherever the newspaper is delivered.
So, Ms. Faraday, you believe that it was just a mere suspicions, or do you have any concrete evidence or supporting facts for this?
Well, us being one of the leading companies all over the world, we wouldn't be accusing any company just on behalf of only one evidence, and neither did we just come up with one news that was put down in the newspaper. We had seen another article which stated that Riverdale Tidal had faced the same issue.
Please present the article.
Yeah.
Could you please present the article? Could you please state the facts of the article you just mentioned now?
Yeah, it was seen in the part. It was seen in that case that the turbines that were provided by Turbo Energy Limited to Riverdale Tidal Power Plant Limited, there the turbines did function around for 2 years, and then reparation was required from your company, the Turbo Energy Limited.
Ms. Faraday, sorry for interrupting,
Yep.
but that was in the first article. You just mentioned that there was another article that you came across. So could you please state out the facts in the second article?
Wait. Apologies. The case I just referred to was on the first article, and on the second article which we received, which we came across on 3rd October 2022, as the article that was not spoken highly about, but it was the article that made us contact Emre Khan, the chief negotiator of your company, Turbo Energy Limited, upon which we came across, coming across that particular article, we contacted your company's chief negotiator, Emre Khan, and we shared our concerns over the turbines.
Yes, so Ms. Faraday, you just mentioned that there was the second article, which was not that famous. So it was the first article that mentioned, could you please repeat the company name?
It was pretty much vague. It was just the article that was published, and
So-
the facts were not
so you believe-
presented well.
So you believe the article's facts were vague. So what? So do you believe that it was just word of mouth, or was there any supporting evidence or facts to specify that there was the problems with the turbines?
Well, we are not just relying on any particular article. We are relying on both the articles, and the reason why we relied upon them and the reason why we got concerned was because it was the duty of Turbo Energy Limited to come up and let us know about this before delivering this to us. It was somewhat damaging to us too, because we were unaware of it, and we completely relied upon you guys with the acceptance test. And we, being the
So
receiver,
firstly,
the buyer of your product, we should be aware of what actually happened.
Ms. Faraday, sorry for interrupting you again. So you mentioned that you're relying on the company for providing you with the turbines. So secondly, you mentioned that you relied on the news articles. I repeat, you relied on the news articles, information which you feel that were vague.
Yeah.
You just mentioned that the second
No,
article was vague.
So we are not saying it's vague. It's like the facts were not stated properly.
Yes,
It's
so the
not
facts
vague.
were not stated properly. So you believe it's the word of mouth and not a concrete.
I will repeat myself again. I am not relying on one particularly. And I will tell more about it. It was also informed that the heat that will be given to the alloy that would alter the manufacturing, that the heat that is given in the manufacturing process, that would alter the steel, and not just would alter it, but that would make it more susceptible to the corrosion and the breakage, the cavitation damage and things.
Okay, so I'm just repeating your word. It would make it susceptible to the damages. So you suspect that it will cause damage to the turbines?
Susceptible, not susceptible. Susceptible.
So are you so is this a reliable source?
What?
The news article.
No way. I'm a Yeah, you mean then was the news article that was provided in the article is reliable or not?
Could you please repeat?
Could you repeat your question, please?
Do you believe the news article was reliable?
No, we are not just completely relying on articles. It was
Yeah.
a collective. It was a collective decision. We came across the articles, the news that we got, whatever was explained from the other end, from your company, and not just that, and upon knowing all of it, we just wanted to clear our doubts with you all.
Okay, so I'm just repeating your words once again. So correct me if I'm wrong. So you just said that you wanted us to assure you from the company. You wanted the respondent to just have the facts ready, right? So you said that the news article that you came across was a collective decision that you said that there was damages in the turbines due to the heating procedure.
Yeah.
Is it correct?
No, due to the heat used in the manufacturing process, the
Yeah.
alloys used in the turbines would be more corrosion resistant, and that would make it susceptible to corrosion. No, sorry, that would be more susceptible to the corrosion resistance, the corrosion and the cavity damage.
And the cavity damage. So this was a collective decision of your company to.
It was not just us wanting, to get to know about the facts from your end. It was us. What we wanted from you guys was to replace the blades in the turbine so that it would function well enough for the plant to go on, and so that the promise we had made to the Council of Green City was fulfilled.
Okay. Now moving on. So you had a exchange of emails with Mr. Binod Kumar.
Yeah.
You had
Couldn't hear you. Stopped.
Okay. Am I audible now?
Yeah.
Okay. So you had an exchange of emails with Mr. Binod Kumar.
Yeah,
Right.
definitely.
Right. So in the exchange of emails, what was promised by Mr. Binod Kumar?
Binod Kumar had offered us, can you refer to the date? Because we had several emails were exchanged. Could you refer to the date?
4th October 2022.
Yeah, upon that email, it was stated by Binod Kumar that they would repair, and not just repair, they would fast forward the inspection by 2 years. They would proceed with the inspection after 1 year from the date when it was, when the turbines were produced and given to us for the, I'm sorry, I'll just check it for one. It was October, 4th October. Yeah, here it was given that they would just, they would run the first inspection. That would be right after 1 year from the, that would be pull forward from September 2023 to September 2024 to find out that whether there was any problem in the turbines, to ascertain whether the turbine runner or the blades were produced from steel of inferior quality, and and then let us know about any action. But that was not what we wanted, because in case that was pulled forward, that wouldn't help us, because if the blades used were not the proper ones, then we would have to face a lot of damage from the Council of Green City, and we had to pay 40 lakhs per day for the unavailability of the turbines. And
Ms. Varadi, I'd like to interrupt you. You just said that your company would face a lot of changes in case of the turbines not working well. So according to the facts of the case, the Green City requires you to function the hydropower for 11 months. Am I correct?
At least 11 months, yes.
Yeah, at least 11 months. So as you've read the news, I'm pretty sure, even though it was vague, as you've mentioned. So in there, the whole time taken for the replacement was more than a year.
Yeah.
The time taken for the replacement was more than 1 year.
Yeah.
So in case you're asking for a replacement now, wouldn't that cause you much more damage because the turbines would take much more to make? I mean,
Here-
or more than 1 year?
Here's the thing. We just did not want our doubts to be clarified and not replaced. What we expected was some sort of confidence. But when Turbo Energy themselves, they were not confident about their product, and they were willing to give us an inspection right after a year. That was not just giving us enough confidence. And yeah,
Ms. Faraday, I think Mr. Binod Kumar promised you that in case of any corrosion before the date of inspection, which was in September 2023, they would offer to replace it by then.
no, we are not suggesting that the replacement of the blades are to be done right now.
Yeah.
Upon the first inspection, we would be happy to have the the blades changed.
Okay, so you
No,
agree that
Yeah, if
you agree that after a year, after the inspection and maintenance, and if there's any corrosion, then only you'd want further
Yeah.
replacement.
Could you repeat your question, please? I'm sorry.
Okay, so you agree that after a year, when they have the inspection and if they find the corrosion, then only you want the replacement, not before that.
We're not saying that we're not saying that we want them to find the corrosion. We are here that we want a good product, and that means that we want the first inspection after 2 years, and when after the 3 years the inspection is done, and we want to get a report after that, not just right after a year. We wanted the confidence from Turbo Energy so that we could rely on the turbines properly.
So you just mentioned that after 3 years, but I think Mr. Binod Kumar offered to move the inspection date, that is after a year. What Mr. Binod Kumar has said is they want to wait for a year, and after a year, they'd start the first inspection for the repair and maintenance. And then only if they find any corrosion, then they would replace the whole turbine.
Well, it was not said by Binod Kumar that they would replace the turbine. They were insisting that they would just repair and maintain it, and they would just, and upon finding any issue in the blades, they would just repair it. They did not mention they would replace it, and that replacement is what we wanted, and that's what we're here for.
So according to the facts of the news, which you said you would come across, okay, once.
I hope you guys are keeping track of time yourselves, and I need not remind each party every time. Thank you.
Sure, sir. Okay, Ms. Faraday, so as you come across the news article, it is mentioned that river tidal, when the corrosion was found in the river tidal's turbines, it was replaced after a year. So I'm pretty sure that Mr. Binod Kumar has promised with the replacement and not only the repair and maintenance.
Well, the negotiation that I had with Mr. Binod Kumar, in that negotiation, Mr. Binod Kumar had stated that he would repair the blades and not replace it. And that has been the issue that we have been talking with Mr. Binod Kumar over the time, that we want to replace blades and not just repairment of it.
Okay, that's all. Thank you.
Claimant may please proceed with the examination chief of second witness.
May I please call Mr. Gillian Lawson? Good afternoon, Mr. Gillian Lawson. Would you like to give a brief introduction of yourself? Mr. Lawson, you're muted.
My apologies. I'm Gillian Lawson, the councillor of Green City, which is a town located at the hillside of Chittagong. We have been a very progressive in maintaining a sustainable city, and our most recent initiative was our most recent initiative was to establish a no carbon policy, and we were very enthusiastic about that project, and have been planning to plant hydro pumps so that we can avoid using dirty energy from the Sundarban coal power plants that is near Chittagong.
Can you please tell us about how you would have avoided using the renewable resources?
Yeah, so as I mentioned earlier, we were gonna plant some hydro pumps, and we issued a tender for building and operating a hydro pump. So Hydro Pump PLC was granted the contract as they promised a special turbine, the R27 Francis turbine, which according to the description would have enabled a more environment friendly and efficient approach. And the two turbines would provide about 600 megawatt energy per year. The primary purpose of that contract was to completely eliminate reliance on carbon-based energy.
What was the tender agreement? Can you tell us about the agreement that you have made with the respondent?
Yeah, we were promised by the Hydro Pump PLC that their turbine will reduce the maintenance and inspection, and inspection will take place once every 3 years. It was asserted by them that the turbines they will use, manufactured by Turbo Energy Limited, the respondent, is corrosion proof and less susceptible towards cavity and damages. We required the hydro pump power plant to produce 600 megawatt energy per year. Therefore, we have a penalty clause in our tender agreement that Hydro Pump PLC will pay us 40 lakhs Bangladeshi taka every day we have to use coal energy because of the hydro pump power plant is unavailable.
And what was the problem in the turbines in your power plant, Mr. Lawson?
Yeah, after plantation of the turbines, we learned from an investigation which was priorly brought to our knowledge by Mrs. Maisha Faraday, CEO of Hydro Pump PLC, and also confirmed by our investigation that the respondent party had used defected materials in their turbines and installed these defected turbines to our power plant. This would mean that the turbines are extremely susceptible to corrosion. We also came to the knowledge of the matters which were brought to light by the Renewable Energy Daily News, the respondent's biggest steel supplier. Goods quality steel is connected to fraudulent activities like forging documents and supplying defected steel. We also found out that the respondent is connected to a faulty power plant as the known as the Riverdale tidal power plant, which was subjected to serious losses due to the usage of steel from good quality steel. Their plant was so much damaged that they had to replace their turbines within 2 years after plantation, and it also put their entire plant at risk of damage. Moreover, it took 13 whole months to replace that turbine. We cannot ever afford so much loss of production because that would mean that the power plant we paid so much to make is useless, and it goes against our city's most important policy. We are called Green City for a reason, obviously. We cannot afford using so much coal energy every year.
And what have you done regarding this argument?
Well, our investigation further showed that the characteristics of the special alloy had been altered by it during the manufacturing process. Our report showed that this plant will need to be inspected and repaired within 3 years, and that will take 4 entire months, and that too if there are only minuscule findings of corrosion. If there is more corrosion like we are estimating, it would mean a lot of more work in repair. So consequently, the pressure on the use of carbon-based energy will only increase in the future, in direct contrast to the promises that were made in the tender agreement. Thus, the very reason to grant the tender to Hydro Pump PLC would be breached. So we want a complete replacement of the turbines. Anything short of that is unacceptable. Moreover, under the penalty clause in tender agreement, Hydro Pump PLC will give us 40 lakhs Bangladeshi taka per day due to the unavailability of power plants leads to us having to use coal energy.
That is all, Your Honorable Arbitrator.
Thank you, counsel, for the claimant, for the examination chief. And thank you, the witness. Now, the counsel for the respondent may please proceed with the cross-examination. Thank you.
Okay. So, Mr. Lawson, am I audible? So what was the main reason for your for the company to award the tender?
Sorry, could you repeat that, please?
What was the main reason for the company to be awarded with the tender?
The main reason was, as I mentioned earlier, that they promised us a special turbine that will produce more energy and that is more environment friendly. And they promised us that we will have to we can completely live using the coal energy or any sort of dirty energy.
Okay, so you believe that the main reason for the tender to be awarded was because of the turbines?
Yeah.
So you believe the company holds a great reputation?
Sorry?
So you believe that the turbine company holds a great reputation?
Yeah, obviously, as they promised, they showed very promising description of their turbines.
So talking about your witness statement, in the last paragraph, it mentions that, you're just repeating your statement, then I, without actually believing everything that she just said from her mouth, did some digging on my own. I inspected the quality of steels myself and the places where it has been supplied to. So what were the other companies that you contacted?
The Riverdale Title Company.
And what was the inspection that you conducted?
We found out after contacting Riverdale Title Company that they used good quality steels products, and their turbine was so damaged that they had to replace it, and their entire plant was put to a risk. And because they used the good quality steel.
Were they specific enough to tell you that it was because of the steels that the damage had occurred?
Well, that is not the only information we had. We investigated and found out, obviously, that they had the special alloy that they used was defected during the manufacturing procedure.
Was this the only company involved, or were there other companies?
To our knowledge, according to our records, we can only talk about the Riverdale Company as facts.
Yeah.
But according to the newspaper showed several.
Could you please mention the several companies?
I could mention the several companies, but we don't have specific specific records to show that those companies were actually connected to this.
So, Mr. Lawson, so you believe that you don't have any concrete sources?
Riverdale Title Company is a very concrete source.
Yes. So it is only the one company that had the problem? Is the one company
according to our records, Riverdale Company was the only company to face this problem. But according to the newspaper's report, there are more companies, and the newspaper report is a daily newspaper report only focusing on renewable energy.
Yes.
And,
so you were
and obviously we investigated more. We investigated more into this. And when we investigated more into,
could you please, Mr. Lawson, sorry, could you please elaborate on your inspection then of those companies?
Yeah, you are focusing too much on the companies. I'm saying we inspected concretely the Riverdale Title Company.
Sorry to interrupt, Mr. Lawson. Yeah. So you just told me that I'm focusing too much on the company, but I think the whole suspicion in this, all this, it doesn't have a concrete supporting facts, and this is just
I
because of
never
the
mentioned about other
Arbiter-
companies. I never mentioned about investigating other companies. I
May
mentioned about
I,
investigating only one company.
may I
Sure.
please hope you guys are looking at your watches and monitoring the clock yourselves?
Sure, sir. Okay, so
Okay.
continue with Mr. Lawson. So you just said that it's just one company, and do you believe that in case of any problem caused by one company, you cannot only say that just because one company had it, all the company has. Same wise, like the turbo company has a reputation. The turbines had the turbines company has a reputation as well. Do you believe?
I'm sorry. I'm sorry. I'll have to give the other team also the same amount of time, and you need to wind up, please.
Okay, sir. That's it for the questions then.
Thank you, counsel, for the respondent, and thank you, the witness. Now, may I request the respondent's coordinator to please introduce before the opening statement. Thank you.
Honorable arbitrator, we have presented a third witness which we would like to present as submitted previously.
You know, you have taken the time, whatever was allotted to the entire team. If you had to produce more number of witnesses, then you could have adjusted the time accordingly. 10 witnesses could be produced in 10 minutes, and one witness alone can take 10 minutes. So I'm sorry, I can't modify the rule and allow you, otherwise I'll have to allow the same concession to the respondents also, which will not be fair. And let me hear the respondents' counsel's objection on this, please.
I think we will not be needing that extra time.
Respondents' counsel, please comment on the additional witnesses which is being introduced by the claimant. Do you have any objection, please?
Yes, I think that's going to be a lot time consuming, and we will not be able to present our views according.
Okay, fine. So we will now wind up the case for the claimant, and as per the schedule, the tribunal allows the coordinator for the respondent to introduce his team before making the opening statement. Thank you.
Thank you, respected arbitrator. Greetings, everyone. It's me, Parag Kafle, representing PASA Associates from Kathmandu University School of Law. We are representing the respondent side in this case. The first, me myself as a coordinator, I will be also playing the role of the first witness, which is Kumar, to the respondents. Then we will have opening statement by Counsel Archana Shrestha for 10 minutes. Then we will proceed in examination of first witness, which is Binod Kumar. Then we will give the allotted time to the cross-examination of our witness. Then we'll be moving to the arguments. Then we'll end our witness examinations and hopefully be moving to arguments and submission by the claimant side. Thank you. Now I'd like to request Archana Shrestha to start this. I'd like to request Archana Shrestha to go for opening statements from respondent side.
Your time starts now.
Okay. Good afternoon, Honorable Arbitrator and esteemed colleagues. My name is Archana Shrestha, and I am the opening counsel for the respondent side. I am representing the respondent Turbo Energy Limited in this arbitration case. And for the time period of next 10 minutes, I shall be addressing the respondent submission number 1 and 2, which is the respondent were not in the direct breach of any of the contract with the claimant, and the respondent did not commit any of the fraud to the claimant. Entering into the first issue, we contend that the respondent were never in fundamental breach of any of the sales agreement or the contract with the claimant. For this, we put forward two main reasons. The first one being the delivery of product as mentioned in the contract. So as per Article 2.1 of the sales agreement, the respondent were obliged to produce, deliver, and install two newly developed Francis turbine R27V in the Green City, and which the respondent did expressly by the duty. And the respondent provided the turbine on in late spring 2022, and the plant started its operation in 19th September 2022, which means that there was there were relevant authorities. The claimant approved the turbine. There was acceptance test and many test runs for the turbines. And as per the witness statement submitted by the claimant of Ms. Maisa Farade, the CEO of claimant, it is written that there was acceptance test and it was completed successfully, which means they gave a green signal to the turbines that were being provided to the claimant. And so the product that the respondent provided were as per the specification given in the contract. And the second reason that sums up that the respondent are not in the fundamental breach of the contract is that there has not been any direct breach of any of the implied or expressed terms of the contract. So the plant, as per the facts of the case, the plant started in 19th September 2022, and the article regarding the forgery of documentation was published on 29th September 2022, which was 10 days after the beginning of the operation of the plant in Green City. And in this case, the forgery of documentation was done by one of the independent subcontractor of the respondent as per the facts of the case. But we submit that there is no implied or express liability to the respondent when it comes to bearing the liability of negligence of its subcontractor. For this, we put forward a precedent case of Norta versus Johnson, the Irish case, in which the Irish Supreme Court held that the main contractor cannot be held liable for the negligence or the faulty design made by one of its subcontractor. And furthermore, the forgery of documentation was one of the frustrating event that invoked the doctrine of frustration in this contract. There was no direct connection, direct link with the link of the respondent towards this frustrating event. And furthermore, in the case of Ravindra Singh Shankar Singh Thakur versus Hindustan General Electric Corporation Limited, it laid out the principle that one can only sue for the loss occurred and not for the future possibility of failure of working. So to claim for the loss or the damages, there should have been incurred some kind of damages or the loss. Until and unless there has been incurred any kind of damages, one cannot sue someone for the risk of potential future injury. And the person should show the loss that is undertaken to be entitled for its remedy. So these are the two reasons that we contain. These are the two reasons that we contain content to say that the respondent were not in the direct and fundamental breach of any of the contract with the claimant. And furthermore, the respondent are willing to prepone the inspection by 1 year, which was initially scheduled on 19th September 2025. But the respondent are willing to prepone the inspection date by 19th September 2023 and September 2024. And the preponing of the inspection is reasonable and required because as per the facts of the case, the replacement of turbine will take more than a year, almost 13 to 14 months. Which means the Green City Power Plant will be out of its operation for more than a year, and this will cause the loss to the Green City, to the claimant, and to the respondent. The Green City would have to rely on other sources, and their no carbon policy will be failed. And furthermore, and the inspection is one of the valid option and a reasonable option in this case, because the inspection would only take 4 to 6 weeks, and in comparison of 4 to 6 weeks of unavailability of the plant to 13 to 14 months of unavailability of the plant, the inspection is far more better than the far more better than the replacement of the turbines. And furthermore, in an email exchange between the CEO of two companies, Turbo Energy Limited and the Hydropower Pump PLC, the CEO of the respondent, Mr. Binod Kumar, explicitly mentioned that if there is any kind of corrosion or any problem with the turbine, then the turbine will be repaired as soon as possible in the nearest factory. There was no mention of replacement. So the claim of replacement from the claimant is unreasonable in this case, since the claimant or the CEO of the claimant company did not object to the offer of repairment in that particular time. So the replacement in this asking for replacement in this period time is unprofessional and unreasonable. And until and unless some kind of inspection is done, we cannot be sure that there is a problem in the turbine, because the turbine is well delivered, well installed, and is well operating in present scenario. And until and unless we do the inspection, we cannot be sure of any kind of problem being occurred in the turbine. Taking a risk of more than 13 to 14 months for the replacement of turbine is baseless and unreasonable in this case. And moving forward to the respondent's second submission, that is, the respondent are not in fraud of any kind in this situation. That is, the Section 17 of Indian Contract Act defines fraud as an active concealment of information from the other party. Putting light in this particular clause, we contend that the respondent were never involved in any kind of concealment of facts from the claimant. As per the of the case, the reverted tidal plant was restarted on June 20, which means it was stopped for 13 months, which dates back to the operation stopped in May 2021. And since the respondent here provided the claimant with turbine in late spring, which means the production and manufacturing of the turbine claimant were started on early March 2020. This time frame gives view that the turbine that were to be provided to the claimant were before the operation was stopped. Furthermore, since the turbine in the Riverdale was completely replaced, neither repaired nor inspected, so the core reason behind the stoppage or the corrosion of the turbines was unclear to the respondent as well. The article that published in October 2022 was what brought this light to the respondent that there has been forgery in the document by independent subcontractor. And furthermore, the witness statement submitted by the claimant of Mr. Emre Khan, the chief negotiator of the respondent company, it confirms that the steel used in the turbine cannot be cleared corrosive or non-corrosive because of mere and some random acts. It would require a proper inspection. It would require proper maintenance, and so for the same reason, we the respondent are trying to pull forward the inspection date by 1 year, which would be beneficial economically to both the claimant and the respondent, since they would not be since the plant would be in operation for 1 year. And we also submit that there was indeed false documentation in reverted tidal plant. However, it does not mean that the same case has happened to the claimant, the hydropower PLC here. So to know whether the turbine is corrosive or not, that's why we are pulling forward the inspection. We are focusing on the pulling forward the inspection date by 1 year. Instead of replacement, and since replacement was never in the contract, neither it was expressed or implied in the contract, so replacement is out of the question in this case. In this case, if Mr. Arbitrator has no any question, then I may conclude my submission.
Thank you. opening counsel for the respondent for the opening statement. The counsel for the respondent may please proceed with the examination chief of the first witness. Thank you.
Hello, am I audible?
Yes, please, you are audible. Please proceed.
Okay, I would like to call my first witness, Mr. Binod Kumar.
Thank you so much.
Please introduce yourself.
I am Binod Kumar. I'm the CEO of Turbo. I'm the CEO of Turbo Energy Limited, which is a world-renowned producer of water turbines.
So as per the witness statement given by you, you were unaware about the article that was posted. So when were you aware about this happening?
Sorry, pardon?
As per the witness statement given by you, you were unaware about the article that was posted. So when were you aware about this mishappening?
I was aware on 3rd October when Miss Maisha Faraday had notified it to our chief negotiator.
So do you believe the company was involved in the fraud case?
No, I do not believe the company was involved in first case. Neither we are trying to conceal any kind of information that was provided to us. It was sole responsibility of the CEO.
So, Mr. Kumar, so could you please explain about the relationship between the company and the subcontractor Good Quality Steel?
Yes, of course. We had a really good business relationship, and because of their product and because of their help, we have earned a lot of goodwill to our company, and we stand today at large because of their product.
Mr. Kumar, as mentioned by the claimant witness, they have mentioned that it was not only the one company with the problem with the turbines, there were other companies. So do you believe there are other companies which face the same issues?
No, I do not believe there are other companies which face the same issues, because such level of issues, we would have known if any company would have faced such level of issues. We just came to know about Riverdale through Maisha Faraday, which contacted our chief negotiator.
So correct me if I'm wrong. So you believe that there was no such instances in which the use of alloy caused problems in the turbines of other hydropower projects?
I do not think so, because I'm not aware of any other complaints from any other companies.
So talking about the exchange of emails between you and Ms. Faraday, could you please explain the terms you discussed?
Ms. Faraday insisted on replacing of the turbines continuously, but I had assured her that if any corrosion had occurred during the time of inspection or before the time of inspection, we would gladly repair the given turbine that is being used in the hydro pump.
So what would be the estimated time for the replacement?
As we could take reference of the Riverdale incident, I would say basically more than a year, because now we have to search for another subcontractor as well, because I'm also in shock that they committed fraud, and it does not lie in my business ethics to hire the same contractor again. So we'll have to search for a new contractor, as well as we'll have to prepare the blades. So it's going to take more than a year.
And what would be the time required for the repair and maintenance?
The time required for the repair and maintenance would be 3 to 4 months at maximum.
So the company believes that it would require less time to repair and maintain than to replace.
Yes, obviously, because to replace, we have to construct new turbines, as well as hire a new subcontractor to supply us with good quality steel.
Have you tried contacting the subcontractor Good Quality Steel about the fraud case?
No, I have not contacted them, because I just don't want to be contacted by them, because I trusted them with their quality, and then to know that they have committed a fraud.
So, Mr. Kumar, sorry to interrupt you. So do you have another subcontractor who is willing to supply you with the good quality of another alloy?
No, at the moment we are in absence of such subcontractors.
So you agree that it will take much more than 1 year if you don't have a particular subcontractor?
Yes, of course.
Would this cause your company to be in a loss?
Yes, of course, because we would want to uplift the contract with the clients, the claimants. So I think it will be a loss for us as well.
Okay, that's it for the questions. So I would like to call upon the cross-examiner to question the witness.
Thank you, counsel, for the respondent, for the examination chief. And I now invite the counsel for the claimant to carry out and proceed with the cross-examination of respondent's first witness. Please proceed.
Much obliged, Your Honorable Arbitrator. Good afternoon, Mr. Kumar. Sorry, can you hear me?
Yes, I can hear you.
Okay, can you please confirm that the witness statement that you sent to us was written from you?
Yes, we confirm that witness statement was written by us.
Okay. It is true that you have engaged into a contract with Hydropump PLC.
Yes, it is true.
That means you have read all the terms and conditions that were on the contract before engaging in it.
Yes, of course.
So you are aware of the requirements?
Yes, we were fully aware of the requirement.
So it is true that being such a big company, you have not tested the quality of the steels that have been produced by your supplier before actually engaging into such a big contract, which actually affects the entire environment and the dependency upon the non-renewable resources.
Sorry, pardon, please.
So it is true, right, that being such a big company that you have not tested the quality of the steels that have been produced by your supplier before actually engaging into such a big contract with Hydropump, which actually affects the entire environment and the dependency upon the non-renewable resources.
They have showed us really good quality products in the past, which we have used in a lot of hydropowers and which did not complain about anything. So trusting our subcontractor was basic foundation of our contract. That is the reason why we did not want to question them about their quality.
So it is true that you did not test them by yourself before actually engaging in such a contract.
Yes, we did not test, but during the
installation. Thank you. Okay, so you agree that you were actually negligent before actually entering into the contract, before you agreed to all the terms that you signed with Hydropump, that you have not actually tested it, like you said?
No, I would not say that it's a negligence. I would say that it's a basis of trust that has been built upon various years with our client. And talking about inspection, we tested a really long before, as well as while installing the turbines in Hydropump. There was also an inspection before running, as you recall. There was also an inspection that gave us a green flag to run in the Hydropump.
Okay, but do you agree that you did not test them at yourself, but just ran a test run and did not think about the longevity of the pump and the turbines? Is it?
The contractor we hired had provided us with good quality steels for a long time, and then they have tested their turbines hydropower for a long time, and we have been testing it in various companies as well, not only in Hydropump. We have been testing in various companies, and we did not want to repeat that process again.
Okay. And also you said that in your witness statement that you are aware that they had committed fraud by forging the documents.
Yes, I have mentioned that I got to be aware after Maisha Faraday had contacted our chief negotiator, not before.
Okay. Then you're saying that you know that you won't actually conduct business with good quality steel anymore. But you also told that Maisha Faraday that you would happily repair the materials.
Yes, we would happily repair the material after we hire another subcontractor, which is qualified for the job.
But the base upon which the turbine is actually built upon is not of good quality. It won't last long. So do you actually know that if actually repairing it would actually, serve the purpose of such a big turbine? Are you sure that you know that repairing would actually fix this issue?
Yes, I would say that repairing would actually fix this issue because the corrosion has not occurred. There is only an increased chance of damages. It has not been damaged fully, and we don't know the possibility yet. So I would inspect, and if something is wrong, I would repair and then see for.
So you're agreeing that you actually know that things will go wrong and that you are ready to repair, but actually the base is actually weak because of the poor quality steels that have been provided.
No, I have not accepted to you when you say that I have accepted the weakness of my product. I have just said that before jumping into any conclusion, I would like to check what's wrong. And if it's wrong, then it's our duty to correct it. So I will be proceeding with the maintenance of the stock myself.
Okay. That is all, Your Honorable Arbitrator.
Thank you, claimant's counsel, for the cross-examination. The counsel for the respondent may please proceed with the examination chief of the second witness.
There's no second witness. As our team consists of only 4 members, we don't have another witness.
All right. Now, I would, before the arguments and submissions by the claimants and respondents begin, I want to confirm from both the teams, because we have some time. Do the teams want to utilize this time, or should we proceed for the arguments and summations? The claimants first, followed by the respondents' counsel next. Let's hear the claimants' counsel first on this.
The claimant's counsel would have liked to invite the third witness that we had presented and communicated before.
Okay.
However,
right now, I would request the respondents' counsel to please comment on this. Would there be any prejudice caused to you in case the third witness is allowed at this stage? Because we have time and you can utilize the time. I invite both the parties to utilize this time. Otherwise, if the parties don't want to utilize, we'll proceed further for the arguments. The counsel for the respondents, may I hear your argument on your say on this, please?
Sure, sir. As informed by claimant's senior counsel, they were talking about a third witness. So if there is time, if there's the immunity of time, I would gladly welcome the witness that the claimant are going to present.
All right. The claimant's counsel may please proceed with the third witness, keeping the time parameters in mind.
thank you. I would like to now call upon the representative of Riverdale Tidal Power Plant. Hello, please introduce yourself.
Good afternoon, everyone. I'm a representative of Riverdale Tidal Power Plant.
As the representative, you would know about what happened between you and the respondent, being Turbo Energy Limited. Please explain in summary what actually happened.
We, the Riverdale Tidal Power Plant and Turbo Energy Limited, had a contract where a turbine produced by Turbo Energy Limited was installed in our power plant. After 2 years of operation, the turbines had to be replaced due to excessive corrosion and cavitation damage that kept an adverse effect on our power plant.
Give me one moment, sorry. Can you tell me when did it happen specifically? And how long did it take you to resume the operation of the power plant?
The turbines were first delivered and installed in May 2019. And after only 2 years of operation, in May 2021, we discovered the excessive corrosion, and it took 13 months to replace the turbines. The power plant resumed its operation in June 2022.
Now, when the operation was closed, who did you inform about the situation and who was responsible for the replacement of the turbines?
We informed our supplier Turbo Energy Limited, and they informed the reason behind the problem was damage and the quality of the steel. According to the Turbo Energy Limited, their main supplier, good quality steel, forged documentation concerning the quality of steel, and they were having a fraud issue against them.
Thank you. With that, I would like to end my examination in chief.
Thank you, counsel, for the claimant. And now, counsel for the respondent may please proceed with the cross-examination.
Am I audible?
Yes, you are.
So could you please explain the relationship between you and the company, the respondent company, sorry.
The relationship between our company, Riverdale Tidal Power Plant, and the respondent company was the respondent company sent their turbines to our power plant, which we used in our power plant.
So upon inspection, you found out that the water turbines were corroded?
Yes. When the corrosion and the damage were found, we talked to the Turbo Energy, and they also confirmed that the excessive corrosion and cavitation damage was for the good quality steel, and they sent them some.
So correct me if I'm wrong. So when the corrosion occurred, the replacement, it was after 2 years of installation, correct?
Yes. Correct.
So then the replacement took 1 year?
The replacement took more than 1 year.
Yeah, more than 1 year. So after only 1 year, was it that they found the problem was in the good steel company's steel, which they used to form the alloy?
Yeah.
Is it true? So altogether, it was between the 3 years that this all exchange took place?
Pardon, could you please repeat the question?
It was between the 3 years that all this exchange took place?
Yes.
Okay. So did the company replace the turbines?
Yes, they replaced the turbines.
Okay. What was the charges that was included?
What type of charges you're talking about?
As you know, the turbines cost 20 crores each. So in total, it was 40 crores for the 2 water turbines. So what was the charges that the company had to incur after the corrosion occurred?
As I'm a mere employee of the Riverdale Tidal Power Plant, I am not aware of the business side of the Riverdale Tidal Power Plant and Turbo Energy. All I know about the corrosion and the replacement.
Okay, so do you believe that the respondent were aware about the situation and the fraud case of the good quality steel company?
Yes, as they informed, they mentioned the forged documentation concerning the quality of steel.
So do you believe that it is the word of mouth, or is there a concrete evidence?
As they have mentioned that the material they used in their turbines were not in their best quality, so we have to believe to them as we are conducting business to Turbo Energy.
So you believe that the respondent were aware about the situation, about the forged document?
Yeah.
Or were they tricked into it?
We don't know if they were tripped into it, but as they informed us, they were aware of it.
they were aware of the fraud case that was that the news had reported.
They were aware
So,
of the unsatisfactory quality
yeah.
of the steel.
So as per the witness statement by Mr. Lawson, and the examining the examining and the words spoken by him, he said that he had contacted the company, Riverdale company, about the other companies which were also involved in the fraud case. So could you please mention the other companies that were involved?
We do not know about the other companies as we were according losses on ourselves.
Yeah.
He talked
So you
to
believe
us.
that you had no such conversation with Mr. Lawson?
No, he has contacted to us and we have informed him about the losses and the turbines. So we only informed
So it was
about
only your
our
company
end.
that you mentioned and not other companies.
No, but he wanted to know about the other companies and we say that we
But
do not have any
isn't it a
knowledge
private
about it.
information that you are revealing, that all the agreements between the company, isn't it a private information that you cannot reveal the contract between you and the turbine company?
It is not a private information because it was as far as you know, it is a public concern. A power plant is a public property
Yeah,
and everyone
no,
has the
I'm sorry if you misunderstood, but I'm talking about the contract between you and the Turbo Energy.
it is not a private information that the reason behind the excessive corrosion and cavitation damage.
Okay. So the exchange of information between you and Mr. Lawson only consisted and was only on the peripheral of your company.
Yes.
And did not involve any other companies. Hello?
We were not asked about any other companies, but I do not know about Mr. Lawson's.
Okay, so according to him, the reliable sources and the collective decision was from their company and your company as well, to replace and for asking the replacement of the turbines. What he mentioned was the information sources came from your company. So what do you want to say about that?
I do not have anything to say regarding this.
Okay, then my question's done. Thank you.
Thank you, counsel, for the respondent for the cross-examination. Now, before we close the proceedings, I want to confirm from both the parties if they have anything else to say, any evidence, any witness, anything. If there is nothing, we'll proceed for the final arguments. Counsel for the claimant, please confirm.
Thank you, Honorable Arbitrator. Yes, we would like to confirm and start with the final arguments.
All right. The counsel for the respondent, what do you have to say on this?
We'd like to move for the final arguments as well.
I have not heard. Could you please repeat?
We would like to proceed forward with the final arguments.
Okay, fine. Thank you so much. Now, as scheduled, the claimant's counsel may please proceed with the arguments and summations. Thank you.
Thank you, Honorable Arbitrator. I would like to start off with the issue 3 under the claimant's counsel, claimant's arguments, which is that the sales agreement itself gives rise to an implied term as to repeatedly, and the absence of the express term on replacement does not in itself allow the respondents to get rid of this liability, because under Article 2.1a of the sales agreement, respondents have confirmed commitment to the project. Yeah, they mentioned the email of from the 11th December 2018, where necessary preparations were supposed to be made by them on finding of corrosions. Although we note that this is in relation to inspection and maintenance, as per Lord Wilberforce, implied terms can circumscribe express terms in certain circumstances. They can give this situation can still give rise to an implied term of the implied term of replacement based on the contractual relationships and specific details as per Lord Denning in Liverpool and Lord Brown Wilkinson in Johnston, as well as Lord Bridge in Scally. Contractual relationships of such a nature prioritizes the tender agreement between Green City and the contractual relationship between the two parties is of such a nature that it prioritizes the agreement between the tender agreement between Green City and the a sales agreement in itself. Furthermore, Section 62 of Sale of Goods Act is not expressly excluded. Therefore, this implied term must be expressly excluded if it is to have no effect or sway in the circumstances. The counsel for the claimant also seek specific performance and according to the case of Indian farmers, where the council is seeking for specific performance in an arbitration tribunal. This is valid, and furthermore, we seek such specific performance under Section 12, subsection C of Specific Relief Act 1877, which relates to the non-performance and non-performance not being an adequate relief under the circumstances. The council would like to refer the circumstances where the specific description of the specific turbine produced and by described by turbo energy is of such a nature that it is extremely rare, to which case the claimants, as per the facts, even paid 10% extra more than any other water turbine available in the entire market. Because of this, it would not be affordable and adequate if the specific performance of replacement is not granted by the honorable tribunal. Section 21 or subsection 1 of Specific Relief Act also states that this applies where compensation in money is inadequate relief under the circumstances. And as per the sales agreement under Section 19 subsection 1, the liquidated damages is capped to 10% of the total amount, which is only 4 crores. Whereas under Section 19, Article 19.6, the total amount of damages that can be claimed against the respondent is only 20 crores. Whereas the two turbines were bought for a total of 40 crores. So it is not affordable, and it is an inadequate situation where the honorable tribunal, honorable arbitrator does not allow us to seek the specific performance. Contend that the loss incurred due to the damages payable by claimant to Green City, as per referenced and stated by the various witnesses, and specifically Mr. Gillivan Lawson stated many times that they are owed 40 lakhs per day. Every day the power plant is turned off and they have to use renewable and non-renewable sources of energy, thereby even if the specific performance of replacement is granted, and we are arguing and contending this where it is granted, so this would take a total of 3 months. So and in this 3 months, only two are allowed under the Article Article 2(1)(d) of the sales agreement, which is of September and October. Upon the month of November, the claimant will have to pay the Green City 40 lakhs per day for a whole month. This will amount to 12 crore, and this amount must be paid by the the respondents under the circumstances. We would also like the council would also like to reference under this section 73 of the Contract Act 1872, whereby the claimants can seek such damages. Furthermore, the respondents must also pay liquidated damages under the sales contract, which is of 40 lakhs per day, which is capped to 4 crore. 4 crore. This amount must be paid due to the fact that the operation of the power plant would be stopped in itself only because of the turbines being inoperable. In the facts, there is no mention of anything else, any other factor that would lead to the plant closing down. Furthermore, moving on to the rebuttals prepared for the arguments made by the respondents, they constantly argue that the supplier, good quality steel, is their subcontractor. They have not proved it anywhere under their legal written submissions or their verbal submissions that a subcontractor relationship exists between them. Furthermore, they also contend that 4 months is better than 13 months. Therefore, the council should go for inspection and maintenance. But do they not see the simple fact that there is a direct breach in the terms, whereas 4 months is still more than the 2 months that were agreed upon? Moreover, these 4 months will extend furthermore, where inspection and maintenance is carried out for the first time. Upon revelation of more corrosion, there will be more inspections and maintenance required, and thus it would be a continuous cycle, completely breaching the tender agreement between claimant and Green City, as well as breaching the contract between claimant and respondent. Furthermore, they contend that the acceptance test is enough to move away the liability of the respondents to the claimants, to the products and the details. However, they have through the sales agreement and through their implied terms, implications, already agreed that they will make necessary preparations to follow the Green City and to adhere to and support Green City anyhow they can. So the acceptance test is in itself not enough. Furthermore, the council also contends that that the respondents are directly in breach of the facts, whereby they say that there was no concealment of the matter between a Riverdale tidal power plant, whereas it is specifically stated in the facts that in May 2021, which is 13 months before June 2022, when the Riverdale power plant finally restarted, it was notified that only after 2 years it had become unusable due to the turbines. And it is suggestible and very plain and clear that any company that is so big and so large as that of Turbo Energy Limited would be able to check their own products and defects where they had such a huge incident with their own steel and their supply, to which point their entire argument would be completely unethical, and it would be completely against business terms of contract, as they are not adhering to product quality. And with that, the counsel for the claimants have wrapped up all 4 arguments from their side, as well as sought the relief, which includes specific performance under Specific Performance Act 1872, and furthermore seeks damages under Contract Act 1872 of about 17 crore Bangladeshi taka due to the faults of respondents. With that, the counsel for the claimants would now like to end the speech from their part.
Thank you, counsel for the claimant, for the arguments and summations. Now I invite the counsel for the respondent to proceed with his arguments and summation.
Am I audible?
Yes, please.
Good afternoon, Honorable Arbitrator. My name is Anushka Gautam, and I am the co-counsel of Respondent Turbo Energy Limited, and I shall be addressing issues 3 and 4 mainly, and also the summary or conclusions of our argument. For issue 3, we argued that the respondents are not obliged to deliver and install replacement of R27B Francis turbines. On December 11, 2018, the respondent CEO offered to make necessary preparations upon any finding of corrosion relating to repair and maintenance, which the party still stands for. The email was about repairing upon finding any corrosion, but never about replacing it. I repeat, it was never about replacing it. On 29th September 2022, the leading daily news feed on renewable energy, the Renewable Daily News, published a report about the start of a major fraud case against the CEO of Good Quality Steels, one of the main respondent suppliers, which for a fact were unknown to us respondents. We weren't known about the forgery and also the fraud committed by them until we read the report on the newspaper. We delivered and installed the 2 R27 Francis turbines in the late spring of 2022, soon after the inspection and approval by the relevant authority, which included a test run of the turbines. The plant started operating on 19 September of 2022, as mentioned in the case facts. We were also entitled to manufacture the 2 R27B Francis turbine, which was duly delivered and installed in the Green City plant. Also on 19 September, when the plant started operating after the acceptance test, CEO of Turbo Energy Limited even suggested waiting until the first inspection to be pulled forward from September 2023 to September 2024 to ascertain whether the turbine runner or the blades were produced from steel of inferior quality, and then decide upon the necessary action. So in our case, the claimant cannot reject the turbine and ask for a replacement because we provided what was described in the contract. It has had no corrosion till now, and inspection is yet to be done. Even the claimant approved the acceptance test. It is to mention that Good Quality Steel had been our supplier for a long time, and our company didn't face any situation like the Riverdale plant. So even if the feed is true, it doesn't necessarily mean that we were also provided with lower quality steel by them. Coming back to the issue 4, the issue 4 was about the respondents are willing to pay damages as they see it reasonable. Clarified in issue 3, accusation formed under suspicion and doubt without full conformity of the situation has no base in civil law. Not any of the articles that claim the faulty quality of respondents' turbine had come up with authoritative evidence and inspection. The inspection and test run of the turbines immediately after the installment had shown no defect and had given the respondents' turbines a green flag. If the claimant bears the cost, it is not because the respondents didn't provide the necessity. The respondents had fulfilled the duty given in the sales agreement. The only inconvenience claimants will face is the pre-pond time for inspection, in which there will be a loss of 90 days. Given in the Article 19 subarticle 3 of the sales agreement that states no liquidated damages are due up to 50 days of downtimes or reduced production capacity associated with the first inspection. Due to the panic and distrust of the claimant towards the respondent, the first inspection has to be forced earlier. Therefore, the respondent shall only be liable to pay the remaining 40 days of inconvenience caused by the first inspection. Similarly, Article 19, subarticle 2 has mentioned that the overall amount of liquidated damages shall not exceed the amount of Bangladeshi Taka 5 crore. We abide by this and will pay Bangladeshi Taka 5 crore for any inconvenience. The respondents will not pay any other damages claimed by the claimant because the claimant has not suffered any losses. So this was issue 3 and 4. Coming back to the rebuttal by our claimant, the claimant has mentioned that we haven't mentioned anywhere in our case facts or in our memorial that the good quality steel were our subcontractor, but I don't think they looked twice or clearly on our case fact respectfully, but we have mentioned that we have had a very long-term relationship with good quality steel, and we've had many agreements, and also we had many contracts with them, and we found none coercion or any other defects with them. We had mentioned in our witness statement as well and in our memorial as well. Please have a look at it. Thank you. So now I will be talking about the relief sought by our respondent team. So now we seek relief of, by the way, an award of time for inspection of quality of the turbines. We seek time, by the way, of a reduction of damages claimed by the claimants from Bangladeshi Taka 17 crore to Bangladeshi Taka 5 crore, as mentioned earlier. By an award which upholds the sales agreement's Article 4, that is, the claimant shall pay the mentioned amount for additional turbines. We also would like to defend ourselves by saying that there is no direct fundamental breach of the sales agreement, express terms and implied terms under the contract and the statute. We are not liable for fraud under Section 17 of the Contract Act 1872, and we are not obliged to deliver and install replacement of R27B Francis turbines fit for the purpose. And lastly, we are not liable to pay damages for the loss incurred upon the claimants of an amount of Bangladeshi 17 crore, but only liquidated damages of amount Bangladeshi Taka 5 crore. Also, the forgery was not the fault of respondents, and I would like to conclude my argument by saying that we agree for the repair, but not for the replacement. Thank you.
Thank you, counsel, for the respondent. And I would request the host now to take on the stage and prepare for the photograph before the results are announced, because in the program it is mentioned photo session after the results. So I would suggest that the photograph be taken before the results are announced for obvious reasons. So I am now leaving the show for time given to me to the tribunal for prepare of the, and then I'll come back. And in between, you can organize the photo session.
Honorable arbitrator, may I ask a question?
Yes, please.
May I add a point that our fellow respondent actually said?
Look, I had asked specifically both the parties for any evidence, any statement, any witness, anything before closing. And I gave full opportunity to you to present your case. Final arguments. And thereafter, the cross-examination and thereafter re-examination. It leaves no scope for any rebuttal or rebuttal. If you strongly feel, I'll have to invite the objection of the counsel of respondent to this request. Yes, please, counsel for respondent, what do you have to say on this?
We would like to reject the request because the fellow claimant had time for rebuttal.
So the tribunal feels that there are no issues left after the final arguments, and the case should be left here. And I would request the host to please take over the stage and let me proceed with my preparation of my feedback and the results. Thank you.
Sir, can we take a picture before you go for the results?
Yes, you can take it now. When I come back, give my feedback. At that time, you can take the photo before announcement of the results. The choice is with you. The
We'll
way
take
you
a
want
picture
to
now.
proceed.
We'll take a picture now.
Yeah, you please decide. You want to take it now? You please take it now.
Okay, we'll take a picture now.
Yes, please.
Everyone, could you please turn on the camera so that we can take a picture? Thank you, everyone. The arbitrator can now
Thank you so
prepare
much.
the results. While the arbitrator is taking time to prepare the results, we will be seeing a short video on introducing BIAC. Today we have with us Ms. Sharmin, Head of Legal, the Citibank Limited. Now may I request Ms. Sharmin to say a few words for our students and audience.
Thank you so much. So, respected and distinguished arbitrator, Colonel Dinesh Kumar Bishnoi, brilliant participants, members of BIAC team, and other distinguished guests and viewers of this program. A very good afternoon. First of all, I'd like to thank BIAC for having me here. It's a privilege to be part of this splendid session. And Citibank actually appreciates the opportunity to sponsor this event. I'd like to thank BIAC for organizing this wonderful event, which I presume is part of the long vision plan BIAC has in promoting arbitration in our country. So actually BIAC has been playing quite an instrumental role in this respect, from organizing various seminars and sessions, training young arbitrators, mediators, holding debates and dialogues for reforms of various laws of our country. And today's event, I guess, is one of them. So, this promotion of arbitration is really, really important. It's really critical in the context of Bangladesh. If we look at the courts, they are quite burdened with millions of cases. I guess you've gathered it from various newspapers that in our country, currently there are 3.9 million cases pending at various courts. And if I refer to banking industry, there are actually 60 banks operating in our country, and around, as far as statistics of Bangladesh Bank, around 237,000 cases are lodged by these banking institutions for recovery of money. And the involved amount is not insignificant either. It's around 2 lakh crore as per statistics of Bangladesh Bank. So with these huge amount of cases, the courts are actually quite burdened. It's not their fault. The number of courts is insignificant to deal with this huge number of cases. So here actually comes the role of arbitration as one of the alternative dispute resolution. And unfortunately, the moment arbitration gained by far hasn't been actually quite expected. But we are hopeful that in the day, with the remarkable role of BIAC and with awareness session like this, ultimately arbitration would be popularized in our country. So I've been actually hearing the last few moments, the submission by one of the participants, and I was quite awestruck by the brilliance and confidence with which she presented her case. And I'm very hopeful that these young participants in the days to come will be the champion of arbitration. And with this note, I will not actually further drag with my speech. With this note, I'd like to conclude. I thank BIAC for organizing this event. I thank Mr. Colonel Dinesh Kumar Bishnoi for sparing his valuable time and his kind guidance to the participants. And I thank everyone to be a part of this and to allow us to be a part of this. Best of luck to the participants. With that note, I conclude my speech. Thank you.
Thank you, ma'am, for your kind words. If I may request the honorable arbitrator of this session if more time is required for the results to be published?
Yes, if you can give me some time, and I'll be ready shortly. I'll come back.
Okay, so we'll take further 5 more minutes, and within that time, all the participants can turn off their camera and the audio, and we'll come back when the results are ready to be published.
Yes, please. Kindly turn on your videos, please.
I am handing over the floor to the arbitrator of this session to declare the result along with his feedbacks.
All right, everyone on screen. All of us have come on the screen. All right. Now, wait for some time for the results to be announced. Before that, I will give out my points to enable you to work on those areas. That is the aim of this exercise and the aim of this competition. Now, I'll be very critical because otherwise there is a likelihood of not comprehending the point which I'm trying to make. In the competition or the real world, we have to be very clear of what we want to say and what we want to convey. I found that the parties are not clear but what they want to convey. I'm not saying, I'm not commenting on the language or the pronunciation. I'm saying so if we don't know, if we can't read, and if we can't remember, and we can't reproduce, and then we look for our notes, and we look for the screen, and then we look left and right. So that gives an impression that there was something left for the preparation. Okay, I'll proceed to the next point. Now, the cross-examination and the cross-examination chief and the production of the witnesses has to be produced in a manner that it builds your case. So you, first of all, you have to establish what is the dispute, what is the problem, and how did you come to know about it? Directly addressing the net outcome or the last thing which should come last, if you strike that in the beginning, then there is a problem, because that build-up will not take place. You have to build up your case. As a story, the end cannot come in the beginning. So that is to be taken care of while sequencing the witnesses. Now, in the cross-examination, the leading questions are allowed. But I found in the examination chief also, the leading questions were being asked, and the other party, the opposing party, was not objecting to it. So I'm not naming which party did not object and which party asked the leading question, but I leave it for you to ponder on it. In the events and the competition, you have to take care of this aspect. You have to immediately object at that very moment. Whatever you want to say, if you let the time pass and then you come out with that, so there may be time, there may not be time, there may be stage, it may not be the stage, it may be relevant, it may not be relevant, it may be material, it may not be material. All these things you lose out on that. So take care of that aspect. Now, the digital monitoring. Now you have to be an expert in this. How do you monitor the time? And how do you monitor the sequence of events? And how do you monitor and communicate and control what is going on? Whether it is an opening address or it is a cross-examination, examination chief or whatever, you have to find ways and means to communicate to your team member. How do you do it? I leave it up to your own innovative ideas. How you want to communicate and control. Okay. Like, I'm not hinting at anything. You could use any mode of communication. I leave it up to you. On screen, off screen, whatever is effective tool you find. Now, the authentication of the document from the witness. Now, there are ways to do it. And some tools were used by you, useful tools, but then you have to, we have to go a long way in achieving that. Effort was made, and I was quite impressed the way it was being done, but that area needs some more practice and some more focus. Now, there are limitations of digital remote hearing, and we all have to be prepared for that. Anything can happen at any time, at any stage, with any party, with any person. So be prepared for that. And another point is, this is my third last point, that you remember the milestones. There is no shortcut. There is no way out. There is no alternative to this. You have to remember the dates, sequence of events, the important milestones. You have to argue on that. You can't afford to lose track of that. And I found that the facts were being narrated without the milestones and without the dates. So that may cause you heavily. Now, my last point is that when you examine the witnesses, you have to see, you want to examine by witnesses or you want to examine by issues. So if you're examining by issues, maybe that one witness is sufficient. And if you're examining by issues, maybe that 100 witnesses may not be adequate. So I leave it up to you. Okay, now this is the time for me to announce the results, and the details of the results will be with you. I have already emailed, and before announcing, I'll just confirm from the host, have they received the mail from me? If yes, then I'll announce.
Yes, sir, we have received.
Okay, fine. So the respondents have taken a lead over claimant as far as this session goes. And the details are with your host, and you may get the details, and I leave it up to you now to get into the nitty-gritties of this. Thank you so much. And if anything is required out of me, you may please ask me now. Otherwise, I wish you all the best for your next rounds. Both of you have done extremely well, and I'm proud of you and your teachers, professors, mentors, guides, friends, to prepare you and to bring you up to this level. And I want to see you at the international and the world level and global level. Thank you so much. Anything from anyone? And otherwise, I would seek your permission to leave.
Thank you so much, sir, for your kind words.
Thank you so much. Bye-bye, and wish you all the best.
Thank
you. Do well
sir.
in life.
Thank you, sir. Congratulations to the team Kathmandu University School of Law, and thank you team of London College of Legal Studies South for participating in the contest. Everyone has performed brilliantly. I would like to conclude the session by thanking the chairperson today's session, and team members of Kathmandu University School of Law and London School of Legal Studies South, along with their faculty members who have worked really hard to train up and prepare their students for this contest. Thank you so much. And Kathmandu University School of Law, you have qualified for the semifinals. Congratulations. Thank you so much. You can leave the Zoom meeting.